So here's where you run into problems with the 1031. We talked about you don't want to buy down in value because now you're not continuing your investment into an equivalent or greater valued property, and the IRS is going to say, hey, where's your deferral? Where's the continuation of investment? You don't want to take any cash or other non-like kind property. All right, so I have a question for you. Somebody comes along and says they want to buy your $20 million property that you own free and clear, but they're having a hard time getting financing, so they say, will you entertain a contract for deed where they give you $2 million down and $18 million over time? He wants to do a 1031 exchange. In order for him to do a 1031 exchange, he needs all of his equity to be liberated and freed up to go into the replacement property because he needs to buy something of equal or greater value and equal or greater equity. If you sell on a contract for deed, you might be shooting yourself in the foot on the ability to do a 1031 exchange. Any accountants in the room that want to admit it? What's the thing about installment sales? In year one, you get to trigger all of the recapture of depreciation in year one on an installment sale. So here's the terrible thing. If you took that deal, you get a small amount of cash. Your real estate agent, though, still wants to get paid his full commission. And then the IRS in the state of Minnesota say, oh, by the way, you just triggered all of your recapture of depreciation in year one. So by the time you're done paying the commissions, paying the recapture of depreciation, your downstroke may be gone. Or maybe you're even negative. So be careful. Don't do seller-backed financing if you want to do a 1031 exchange. Now once, many years ago, I did an exchange for Jim Schwabel, the famous personal injury attorney. He had a property that was a real stinker, and the only way to offload it was to seller finance the buyer. He was doing a promissory note to the buyer. I explained to Jim that he needed to have his equity to reinvest into the replacement property. He said, don't worry. Cash is king, Jeff. I will bring the cash to the closing out of pocket. I will loan the money to the buyer out of my own pocket so that the intermediary still gets the same amount of net proceeds. So Jim was able to fix the problem, the seller-backed financing problem, because he brought in the cash out of his own pocket to loan to the buyer so that the equity still went to the intermediary and the equity could be traced through to his replacement property. So there's a way to fix the seller-backed conundrum, but it requires you to have a lot of cash. Not everybody is a super famous personal injury attorney, right? Okay, offsetting debt relief. When you sell your relinquished property and you go to that closing, they pay off the old mortgage. That feels great. Like you can stand up tall for the first time. I've been relieved of that debt and it feels so good. But now, in order to completely defer your gains, you're expected to acquire a replacement property of equivalent or greater value, equivalent or greater equity, and we somehow have to deal with the fact that you've been discharged of a bunch of debt. There's two ways to fix the debt relief. You can either take out a new mortgage on the replacement property or assume existing financing. So you're basically replacing the debt. Or you can do what Jim Schwabel did, add cash. Cash in will also offset debt relief. So there's two ways to fix the debt relief. Most people opt to take out a new debt on the replacement property. So our friends at US Bank have many tools in the lender toolbox to provide financing to you, right? Maybe that's the way that you fix it. With the Delaware statutory trusts, you're buying a beneficial interest in a DST. There's two ways to fix the debt in a Delaware statutory trust. First, you could mindfully select a DST that is levered The underlying real estate assets already have debt on them, and you want to pick one that's got an equivalent or greater percentage of debt so that when you buy into that DST, you're allocated not only your proportionate share of the equity, but also your proportionate share of the debt. And hopefully the new debt that you're allocated offsets the debt that you were relieved of. The problem is that when the Fed jacked up interest rates real fast, it really became hard to do syndicated deals with a lot of leverage, and so there weren't very many leveraged DSTs. In fact, there were lots of all-cash DSTs or very low-levered DSTs. Well, that's a mismatch because most real estate owners like leverage. They like to get 60, 70, 80% of leverage. So that made it hard to go into DSTs unless you had cash to infuse into the deal. There's another DST provider that actually loans money on the outside, but only up to 50%. And you have to apply for that debt, and they loan it to you to increase your buying power. So there's sort of two models of the DST debt. The debt that's already on there, and the alternative, which is where they loan you money on the outside to increase your purchasing power. Each has their advantages and disadvantages. Questions about debt relief and offsetting the debt relief. I will warn you, many people think, and they put the blinders on, if you net out $500,000 on the sale of your relinquished property, they assume you only have to redeploy $500,000 and buy a replacement property of no more than $500,000. They have selective amnesia with regard to the debt relief. Oh, you mean I paid off a $2 million mortgage? That could trigger a tax gain? Yes. You have to buy a replacement property of equivalent or greater value, including the debt that you were relieved of. That makes it harder to do an exchange. One of the advantages of the DST syndicated stuff is that most of the debt in those arrangements is fully, completely non-recourse debt. If you're going to take on debt, I'd rather take on debt that I'm not personally responsible for, not liable for. The real estate's liable for it, responsible for it, but I'm not. So as we get older, we're trying to reduce our risk. We'll take on the debt. I'll hold my nose and take on the debt because I have to do it to do my exchange. But if I'm going to do it, I'd rather have non-recourse debt. Hold tight for the mic.
On your boat, so if you did a contract for deed and say they gave you minimal down and you had a short contract, say a couple years, and then they paid it, could you do the 1031 at that time if no deeds have changed, it's just a contract?
There's a difference between a mere purchase agreement and a contract for deed. When he buys your property from you on a contract for deed, he has the exclusive rights of possession. He has the risk of loss. If the property burns to the ground, he's the one that's responsible for paying for it, right? Or getting the insurance proceeds. He pays the property taxes, he pays the insurance. He's really the owner of the property for federal income tax purposes because he's the equitable owner as a result of your conveyance via the contract for deed. Yes, you did hold back the bare legal title, but it's more as an enforcement mechanism. If he fails to make the payments, you will initiate a cancellation and try to take back the property. But you don't really worry about the property day to day. That's his job. And you can say, well, no, I own the legal title. Who gets to depreciate the buildings? The vendor that sold it on a contract for deed, or the vendee that's now in full possession and control? The vendee is. So he has bought the property. When you eventually get paid off on the contract for deed and you get this big tsunami of money coming into your 1040, you are SOL. Unless you want to buy one of those qualified opportunity zone investments as an alternative. But that only pushes it out, kicks the can down the line for maybe 6 or 7 years. But that would be a way to fix it. There are some financial planners. Tom Rashad, is he in the room? He would probably work with you to do a loss harvesting plan where he would put you into indexes and harvest as many losses as he can for that 6, 7, 8 years that he's got to increase the amount of loss carry forwards that you got. So in the event that you do trigger gains in the future, he's got some loss carry forwards to mitigate that. That's an awesome tax strategy, but it requires time to implement. If anybody here thinks they may have a large gain in the future, they may want to consider some of these loss harvesting techniques now for that unknown but potential gain that you may be experiencing in the future.
Thank you.
All right, LLCs. We've only got about 10, 15 minutes left, so I want to talk to you about probably the most important topic in the 1031 area. Lots and lots of people own real estate together. Many times when they own it together, they own it in an LLC. A multi-member LLC can be taxed as a partnership and file a 1065 partnership tax return, or it could have elected to be treated as a corporation. Sometimes you see like senior care facilities that have a lot of licensing and a lot of liability. They operate and they own in the same entity, which is a bummer. And it makes it hard to do 1031 exchange reconfigurations when they own it in a corporation. Much better to not own your stuff in a LLC that's elected corporate treatment, but to own it in a 1065 filing partnership tax return. I always ask people, do you file an 1120 or a 1065? I need to know right away because it changes how we talk about this. In the partnership realm, you can do a lot of fun stuff with divvying up the property. Let's say that you've recently enjoyed a step up in basis when your ancestor died and you inherited these partnership shares and got a stepped up basis. You are fine doing a taxable sale because you have little or no gain because you got a recently stepped up basis to fair market value. Your partner over here, who's been in it from the beginning, has very low basis and is at loggerheads with you, does not want to do a taxable exchange. But you both don't want to be partners in the deal anymore, and you both want to sell the property to the highest and best purchaser. You want to do a 1031 exchange and defer your gains. You want to take your money and take your licks. How do we deal with that in the context of an entity owning the property? One way to deal with that is to do a crude, simplistic drop and swap. We could take the LLC and deed the property out. Undivided 50% to you as a tenant in common. Undivided 50% to you as a tenant in common. We could have a tenancy in common agreement. We could even ask the bank that's got the mortgage for their consent. We could change our insurance. We could really transfer the benefits and burdens of ownership to you as tenants in common. We could amend the purchase agreement to reflect that the seller is no longer the entity, but is now the two individuals. In a recent case that came out of New York, there was a last-minute drop and swap. These folks had bought a property 30 years ago for $950,000 across the street from Central Park. Decades later, it's worth $35 million, and on the day of the closing, they divvied it up as tenants in common. 1/3, 1/3, 1/3. Two of them did separate exchanges, one took the cash and ran. The New York Tax Authority challenged the drop and swap. They argued that the benefits and burdens of ownership hadn't really been conveyed. They argued that it was just a continuation of the partnership's activities because it was the partnership that signed the purchase agreement. There's cases called court holdings that stand for the proposition that you can't liquidate an entity and distribute out the real estate and have a really short holding period. But guess what happened in New York that caused ripples of excitement? The taxpayers won. Somehow, some way, they convinced this judge that they had conveyed the benefits and burdens of ownership. And notwithstanding the fact that your holding period was about 13 seconds before you conveyed it to the seller or the buyer, the court agreed that you had the requisite intent to hold it for investment or business purposes. Is that a risky way to do it, the crude drop and swap? Yes. Are there better alternatives? Yes. The better alternative would be for the exchange-minded individual to say, hey, the LLC has owned this property all these many years. I'm going to stay in the LLC and do the exchange under its banner. If you would like to leave the LLC, we can do a redemption and deed you out an undivided 50% tenant in common interest, and you can become a separate co-seller and take your licks. But I'm going to stay in the LLC. The LLC has been a partnership all these many years. Can you have a partnership of one person? No. So the first thing that you do is you ask your former partner, hey, what do you think about a 49% partial redemption? You stay in the old entity with me so it retains its character as a partnership. If you guys are still on good terms, you may say, you know what, I'll take 49% of the proceeds and I'll ride with you for 1%. That retains the entity, and I like that because it's got the same DNA. The same two partners are still in it. If she won't stay in with for 1%, she says, I want all my money. Concurrent with her departure, you could simultaneously gift 1% to your spouse or one of your adult children or someone else, so that that entity retains always two owners and continues to be a partnership. But I prefer to keep her in for a piece if you can. So that's a drop and swap where we keep the taxpayer that's exchange-minded in the entity. That's a more defensible exchange. And she doesn't care because she was going to pay the taxes anyway. All right. You still probably got to notify the lender that you've deeded their collateral. You still have to change the insurance. You still probably want to have a tenancy in common agreement. You still want to make sure that the benefits and burdens of ownership actually conveyed title to her. So you got to go through all the formality. Now wait a minute. Right before closing, she got a call from her tax preparer. In fact, she didn't get a step-up in basis. She has a huge tax liability, and she says, I also want to do a 1031. Stop the presses. We're not signing that documentation. A better way to do it, if they both want to do 1031 exchanges, but they don't want to do them together, is called a 708 spinoff. In a 708 spinoff, that old LLC spins off a subsidiary, and half of the real estate's put in that subsidiary. That subsidiary is owned 99% by you and 1% by your old partner. And the old LLC is now 99% you, 1% her. Both of these LLCs have the same DNA. Both are considered continuations of the predecessor for federal tax purposes. Both satisfy the holding period, and both can do separate 1031 exchanges. Still need to have the benefits and burdens really conveyed. Still need to have a tenancy in common agreement. Still need to change the settlement statement to reflect two sellers. But that solves the problem of how each of the two partners can do a 1031 exchange without being vulnerable to an attack about the holding period in the qualified use, because the LLC just split like a cell in a petri dish. All right. One last trick before I let everybody go. Let's say that there's a partnership of 4 people. These 4 people are in a partnership. You're the general partner and you run the show. They are limited partners. They're quiet. every day of the week you get a call from one of the agitated limited partners, armchair quarterbacking you. When are you going to do a distribution? Why aren't you taking care of the property? Which of these three is the problem one? Admit it. It's him. He's the problem. He's a pain in your tuchus. Now you're going to sell the property. And you say to the attorney, I'm afraid to tick out this property and give him an undivided 1/4 interest in the property as a tenant in common, because once he owns a direct interest in the real estate, a fractional interest, now he can dig his heels in. He can say, I refuse to sign a purchase agreement. I refuse to sign anything. Once you make him a tenant in common owner, he has authority and agency over his interest in the property. So maybe a tick out isn't a good idea if you've got a wild card, obstinate, difficult person in your ownership arrangement. Or maybe he's just perfectly fine, but if he were to die, maybe his spouse is not the one you want to be in business with. She could be the one that's harder to work with. Okay, so for various reasons, we may not want to just do a tick out arrangement to solve the problem. Another way to solve the problem, if you don't want to give anybody a direct ownership interest, is to say to all of the partners, 1, 2, 3, 4, all of us will contribute our interests to a Delaware statutory trust, a DST, and we will become beneficial owners of that Delaware statutory trust. And we will season and hold our interest for some measure of time so we don't have a short-term drop and swap problem. Who will be the administrative trustee? You. You've been the general partner. You're going to continue to be the administrative controller of this because you'll be the administrative trustee. There'll also be a Delaware statutory trustee in Delaware because they have to have one cited in Delaware. All right. The beautiful thing is when the property sells, you are now deemed to have sold your undivided 25% interest because as a beneficial owner of the real estate, you're deemed to own your proportionate share of that real estate. You can do a separate exchange. He can do a separate exchange. He can do a separate exchange, and you can do a separate exchange because you all own separate beneficial interests in the same property. So we've converted from a non-exchangeable partnership entity to an exchangeable Delaware statutory trust entity. That's a really nifty way to solve the problem, but it does require some time to season the ownership once it's converted. Any thoughts or questions about that strategy? Yes, sir. That's fine. Well, let's get him a microphone, though. Get ready with that candy.
Thank you. So suppose you're selling some assets under the same purchase agreement from multiple different entities, and they're all S corps, but they are all sole shareholder. You own all of them. Are you allowed to 1031 through those different entities into the same the same replacement property, a single replacement property, since you're the shareholder of all three of them? I mean, I know they're different TINs, but
are they Q sub corporations where they're disregarded corporations? Are they actual legitimate separate regarded entities? That's really the question you're asking.
Okay, I don't know for sure. I just know that they're S corps. I think that they're.
It's unlikely that they're a Q sub
Okay.
because that's a really rare creature.
Okay.
So let's assume that they're not disregarded subsidiaries of a master corporation. Let's assume that they are all.
I think that's correct.
They are all standalone entities, both for legal purposes.
That is correct.
And for tax purposes.
Yep.
Then you got separate exchanges.
Okay.
You need to bifurcate the ownership of the replacement property proportionate to how much cash each of those co-purchasers are bringing in, and you can't put the entire replacement property in one LLC.
Yep.
It's going to have to be sliced and diced proportionate to how much each of those taxpayers contributes.
Okay. So then I was wondering if there was a front-end workaround where perhaps you
Merge them.
Exactly. Would there be an event? Would it be considered an event if you were to assign everything to one of those S corps from the other S corps? Or would that just be a change in name, you know?
I would want to talk to you offline because my
Okay.
concern is that the merged entity has to be considered the survivor and to satisfy the holding requirement for all of the component constituents that went into it.
Yeah.
And corporate tax law is much more complicated than partnership tax law, and sometimes you actually need a business purpose for this to work and for 1031 purposes. So I would love to talk to you
Yeah.
more about that
Okay.
super complicated
Awesome.
question right at the very end of our presentation when everybody just wants to go home.
Thanks.